Hey, good afternoon. My name is Nadia Nadelsky, and I'm honored to chair this first panel on national and regional specificities of transitional justice discourses. In the order in which they will present, our first panel is panelist is Cosmin Sebastian Cercel, who is a research fellow at the University of Nottingham, United Kingdom. His main research focuses on the genealogies of law and politics in 20th century continental legal history. His paper is titled Anxieties of the Nomos, Fascism, Communism, and Legal Discontinuity in Post-War Romania. Our second presenter is Ella Russmiller, a doctoral student in international relations at American University in Washington, D.C. She specializes in transitional justice as well as comparative and regional studies. Her paper is titled Subject Positions and Social Antagonisms in the Discourse of Transitional Justice in Poland. Third, Eva Clarita Patai is a senior researcher at the Institute of Government and Politics at the University of Tartu in Estonia. She is author of Democratizing History in Latvia, Civic Consciousness and the Politics of History in Re-Independent Latvia, and editor of Memory and Pluralism in the Baltic States, among other things. Her paper is titled Transitional and Retrospective, Towards a Typology of Post-Communist Truth and Justice Processes.
This has been changed, actually.
It's been... Okay. Her paper is titled Transitional and Retrospective Truth and Justice Processes in the Baltic States. Thanks. We also have a paper that will be discussed but not presented by Anna Luleva from the Institute of Ethnology and Folklore Studies with Ethnographic Museum at the Bulgarian Academy of Sciences. Her paper is titled Justice Policy and Memory About Communism in Bulgaria, Dynamics and Current Debates, and it's available in the room on a chair. Where is it?
It's being distributed.
Oh, it's being distributed. Okay, thank you. Okay, finally, our discussant is Vladislav Belorusov, assistant professor at the Department of Transnational Legal Studies, Law Faculty of the Vrije Universiteit Amsterdam. His research interests include comparative human rights, EU law, constitutional theory, and the sociology of law. So we will begin with Cosmin Cercel.
All right, thank you very much. So first of all, I'm very happy to be here. Yes, first of all, I'm very honored to be here. I wanted, my point today is about the first post-war trials in Romania after World War II. The object of this presentation, it is very much related to one question, which would be how the framing of the military dictatorship existent between 1941 and 1944 in Romania as a criminal enterprise affected the state's legal morphology and also the state's ideological underpinnings. While analyzing this, I will draw on the philosophical concept of state of exception, which I understand as a philosophical category aiming to investigate the ontological tenets of the law. And the main argument that I've tried to make here is that the war crime trials and the legal framework of that time, of 1946, 1947, failed to mark a return to a stable polity, by, in the same time, failing to address the material history of the Holocaust perpetrated by the Romanian state. So, before moving towards the main part of my argument, I would like to give you some insights on my conceptual framework. So what I understand by state of exception is I'm drawing on a concept developed by Italian philosopher Giorgio Agamben, who himself is drawing on the concept developed by the infamous legal theorist Carl Schmitt, the concept of Ausnahmezustand, which basically means state of exception. So what I understand in my own reading of Giorgio Agamben by the state of exception is a zone of indistinction between inside the structure of the law. I understand him as being a philosophical concept which builds upon constitutional practice and legal provision, existing in various modern constitutions, consisting in either the suspension of constitutional guarantees or the whole legal framework. In short, the state of exception is a conceptual area where it is logically impossible to make any relevant distinction between law as a normative category and fact as a descriptive category. In Agamben's words, the situation created, and I quote here, "The situation created in the exception has the peculiar characteristic that it cannot be defined either as a situation of fact or as a situation of right." So, in order to move further in this argument line, my focus is here in this paper, but also in my overall research project, is to take a look at historical moments in which the state of exception can be pinned down in the historical reality of Romania. And for the purposes of this presentation, I will focus only, or I will highlight only 4 historical moments. First of them is the royal dictatorship of King Carol II between 1938 and 1940. The military fascist dictatorship of the Iron Guard and the military dictatorship of Ion Antonescu between September 1940 and January 1941. And then the military conservative authoritarian dictatorship of Marshal Ion Antonescu between 1941 and 1944. And as a fourth moment, which is important for the purposes of this presentation, is the partial restatement of the Constitution of 1923, which was upheld back in 1944 until 1947. So there are 4 constitutional moments, let's say, in which when we can pin down the existence of the state of exception. Still, before the instauration of the royal dictatorship of 1938, there was a constant use of the state of siege in Romania. Between 1918 and 1928, there was no year in Romanian legal history in which the state of siege wasn't used. And then between 1933 and 1938, the whole country was under the state of siege once again. So we can see that already before the institution of the royal dictatorship, there was a presence of exceptional measures in the legal life. And this took several forms. The use, as I said, of the state of siege, also the government by decree, also the direct nomination of governments by the king, or the practice of passing legislation which was criminalizing political activities. For instance, Law for the Protection of Public Order from 1933, the Criminal Code of 1936, which are very problematic legal instruments. And all these legal measures drew or culminated in the instauration of the royal dictatorship of 1938, which, in my view, is an ambiguous attempt of countering fascism by its own means. That means that the dictatorship, the royal dictatorship, included state violence, unregulated state violence, anti-Semitic legislation, administrative practices, which were also sustained by a staging of ultranationalist ideology. Historians of fascism tend to make a distinction between fascism pure and simply, as represented in Romania by the Iron Guard, and the royal dictatorship, which was mainly an ultranationalist staged movement. It wasn't, let's say, fascism pure and simply. So, in 1940, after the fall of France, which was basically one of the main international guarantor of Romanians' independence and sovereignty, the Romanian state found itself in a very peculiar situation, with a fascist a very strong fascist movement inside its borders, which was supporting and pressuring for the support for Germany, with no serious allies around. And in front of this, and with irredentist movement in all neighboring countries, and in front of the territorial losses, the royal dictatorship had to step back. And it was replaced basically by a military dictatorship, headed by Marshal Ion Antonescu, who used to be a second-rank figure of the political spectrum, but who was supported by the fascist movement, which at that time was really strong. And during this short period of time, September 1940, January 1941, we can see a dualism, a form of dualism in power between fascism and conservative authoritarian conservative authoritarian movement, which ended up with a fascist rebellion. Let's say that the fascist movement, they pledged and they pressured for strong discriminatory measures against the Jewish population, which they didn't want to be regulated by the law whatsoever. They just wanted direct actions. Whereas the conservative authoritarians, they wanted to organize everything through administrative and legal practices. What they did starting with 1941. 1941, also Romania joined the war alongside Germany against the USSR. And let's say that the state during the Antonescu, during the military dictatorship, became a necropolitical enterprise, in the sense that we had a suspension of the legal system in various areas of the law. We had the presence of the wartime conditions, which was, we have to recall and keep in mind the fact that World War II was a total war. It wasn't a regular, it wasn't a limited war. And we had the presence of a discursive hegemony of state racism in national ideology. So I would say from my point of view, 1941, 1944, it was the heart of darkness in Romanian state's history. 1944, faced with losses on the Eastern Front and with an imminent Soviet invasion, the king and the National Democratic Bloc, the king who was just holding at that time simply residual powers, they staged a coup d'etat and they oust the military dictator, Marshal Antonescu. In September 1944, we have 2 decrees by which, at the end of August 1944, we have 2 decrees by which the constitution is partially restated, the constitution of 1923, not the constitution of 1938. And this constitution is quite peculiar in the sense that Articles 3 and 6 of this decree leave out the scope of the functioning of the state, the legislative, and the judiciary. So it is only a partial restatement of the constitution. And what is important in analyzing this context, it is also the fact that there was also an armistice agreement between Romania and the USSR and the Allies, led by the USSR. And this armistice agreement in itself, it is very complicated because it disrupts the traditional state sovereignty. So what I'm trying to look right now is what was the legal framework of the first post-war trials against the military dictatorship. So I think in order to analyze this, we have to take a look at Article 14 and Article 15 of the armistice agreement with the Allies, which state that the state was bound to undertake to collaborate with the Allied High Command in the apprehension and trial of persons accused of war crimes. And it also had to dissolve all pro-Hitler organizations. In 1945, there was issued a statute, number 312, which has a very interesting name, very interesting title, which is a statute for the prosecution and punishment of those responsible for the disaster of the country. And this was the legal framework which permitted the prosecution and the trial of war criminals, Romanian war criminals. And one of the most important moments in this post-war trial was the trial of former leader of the country, Marshal Ion Antonescu. And this was organized by the state. And it raises a series of questions. First of all, if we're looking at this statute, and if we remember the fact that the constitutional framework was just partial, we can ask who is the emittent of, who is the author of this statute? And it is the Ministry of Justice, because the parliamentary powers weren't present anymore. We didn't have the country didn't have a parliament at that time. So we can ask also who embodies the state sovereignty at this moment in time. So it's the Ministry of Justice, which is very interesting and very important, because the Ministry of Justice at that time, it was a member of the Communist Party. And we have also to remember that the Red Army was present in Romania at that time. And they pressured specifically for having someone from the communist movement as a Ministry of Justice. And I think it is very important to underline the constitutional dimension of this statute. Because what is symbolically created through the process of criminalization of the former dictatorship, it is a form of production of alterity. It is somehow as the legal system wants to create a line between the former state and the new state. And I think it is also important to take a look at who is considered to be treated as a victim, but as a victim of these crimes. And if we're looking at the statute, we see that the country is considered a victim. And if we analyze the Antonescu trial, we see that we have a series of very strange ethical implications. For instance, we can read astonishing pieces made by the public prosecutors. One of them says that, I quote, "There can be no difference between the massacre of Romanian soldiers and the massacre of Majdanek." Or, "There can be made any distinction in sending to death the youth of the nation and shooting in forest outskirts the deported people." The idea is that only the people who had governmental power were responsible for the Romanian Holocaust. The idea was that in this kind of ethical ambiguity, everyone was a victim. And this was an ideological strategy, well, it was a strategy which was devised by the fact that the communist movement in Romania at that time, it lacked legitimacy. It was a very small movement. And in order to sum up the problems that the whole post-war trial raised in relation to Romania, it is the fact that they failed to restate the nomos, the normal situation. So the state of exception continued to linger on. There was also a structural failure to render historical trauma, which may be very much related to the structural failure of the law to understand historical violence. But there is also a very important problem related to the way in which Stalinist ideology read fascism as a form of false consciousness. from this point of view, many people, perpetrators, they were considered to be victims themselves, victims of false consciousness, which is very problematic. And it's also, here we have the first articulation of the ideological core of Romanian Stalinism, which is based on a basic lie that everyone was a victim. And one cannot make distinctions or assumptions of responsibility. So, thank you very much.